uh, the defense of government. First of all, I've been trying to say to everybody, there was never an arms deal. There was never such a deal. When people use that phrase, arms deal, that means something crooked happened. You entered into a deal. So I've been trying to say, please, can you stop saying this thing about an arms deal? There was no arms deal. There was a defense procurement. Now, as you will recall, soon after the government had approved the preferred bidders, the controversy started, that there was corruption. So in the end, that joint investigation team was established. Auditor General, National Director of Public Prosecutions, and Public. And in our view, did very thorough work to look at every element of this matter. That is, matters relating to the contracts which the government negotiated with the supplier companies to try and find this corruption. And as you will recall, they then said they didn't find any corruption. Nevertheless, the demand persisted, or not the demand, but the allegation that there was corruption persisted for many years. And again, as you will recall, there was a demand while I was the President of the Republic that we should set up a judicial commission of inquiry. And I kept saying, can anybody who wants such a commission kindly give me one fact to justify the appointment of a judicial commission, given the work that had been done by that joint investigation team? And nobody ever came up with a single fact to say, no, here is, even if it's a prima facie information which suggests that there might have been corruption, which would then justify a setting up a judicial commission. So I'm saying that I kept calling for this to say, please, can somebody come forward with this information to justify such an act? And the defense of government. First of all, I've been trying to say to everybody, there was never an arms deal. There was never such a deal. When people use that phrase, arms deal, that means something crooked happened. You entered into a deal. So I've been trying to say, please, can you stop saying this thing about an arms deal? There was no arms deal. There was a defense procurement. Now, as you will recall, soon after the government had approved the preferred bidders, the controversy started, that there was corruption. So in the end, that joint investigation team was established. Auditor General, National Director of Public Prosecutions, and Public Protector. And in our view, did very thorough work to look at every element of this matter. That is, matters relating to the contracts which the government negotiated with the supplier companies to try and find this corruption. And as you will recall, they then said they didn't find any corruption. Nevertheless, the demand persisted, or not the demand, but the allegation that there was corruption persisted for many years. And again, as you will recall, there was a demand while I was the President of the Republic that we should set up a judicial commission of inquiry. And I kept saying, can anybody who wants such a commission kindly give me one fact to justify the appointment of a judicial commission, given the work that had been done by that joint investigation team? And nobody ever came up with a single fact to to say, no, here is, even if it's a prima facie information which suggests that there might have been corruption, which would then justify setting up a judicial commission. So I'm saying that I kept calling for this to say, please, can somebody come forward with this information to justify such an act? And nobody did.
Good afternoon, good afternoon. Good afternoon, royals. Good afternoon, kings and queens of the land. Good afternoon. We are awaiting the trial of President Zuma. Pre-trial is about to start for what we can call framed corruption case against President Zuma. We can say framed corruption case against, boldly says framed corruption case against President Zuma, because when this deal happened, I don't even want to say, let me say when this corruption happened, because it was corruption by government of the ANC to have gone and bought the arms instead of going to acquire for electricity, at least a nuclear deal or a nuclear power station, or what we call a power plant. They should have just went for a power plant in South Africa to resolve the issue of electricity that we currently are suffering. They should have just taken the money to do a nuclear station or a nuclear energy potential. They should have just done it. But because of the corruption that the ANC government and the white government had, or the agreement of corruption that the two had, uh, instead of securing electricity for South Africans, the government of Nelson Mandela went and bought arms in London. Because that was the deal when they negotiated, when they negotiated for 1994, that they will spend the money through their arms company. President Zuma by then was in KwaZulu Natal, as he was not involved in the national government. The arms deal, the people who were involved in the arms deal were President Thabo Mbeki and President Mandela. Those were the people who were directly involved with the arms deal. But they paying President Zuma with the arms deal because there's nothing else that they can use against President Zuma. They just want to use anything which is available for them, just to nail him, just to put him in jail, just to exhaust him, even if they don't win. He's an old man. Let's finish his money through the courts, just to exhaust President Zuma, just to make him run around for no apparent reason. This case is on President Zuma, but it's actually concocted. It's made up charges against President Zuma. The reason these charges are made up against President Zuma is because President Zuma is the only leader in South Africa who fights for black people. He's the only one who um, represent for real the aspiration of black people. Comment if tell us what you think about the trial on the comment section, and as well you can click the like button and subscribe if you are coming in this channel for the first time. My name is Mngoni Mkonto, and this is the Royal Opinion. We're on the Royal Opinion. So you can click the like button and subscribe if you're coming for the first time. And you can comment if you are coming, if you're not coming for the first time, you can put your comment about the trial. We're waiting for the trial, which will start. President Zuma. Let me share again, because when this video started, I shared this video, but I did not comment really about. There was something that I wanted to comment.
Application, and the court postponed the matter to the 17th of May for a pre-trial hearing. On the 5th of April, my Lord, order relating to the application for written reasons for the application which Mr. Zuma filed. And secondly, my Lord, what is outstanding at this stage is the court's order relating to the leave to appeal. Mr. Zuma has filed a leave to appeal against this court's order dismissing the me in this trial, and that order is outstanding, again, of course, according to the court's discretion as to when the court wishes to hand that down. Thirdly, and perhaps most importantly, my Lord, we ask that the court issue an order for the postponement of this matter to trial. That's at paragraph 20.3 of our pre-trial minute. We want the matter to be, we ask that the matter be postponed for trial to the second term of 2025, being the 14th of April 2025 to the 20th of June 2025, and the third term, 21st of July to the 19th of September 2025, and any further dates that the Honourable Judge presiding at the trial and the Honourable Judge present may determine as agreed between all the parties. So we want the trial to start, my Lord. If I could then, and we've attached a draft order for your Lordship's convenience, should your Lordship wish to make use of that. If I could then just return to the beginning of the pre-trial minute to explain in more detail how we got here. My Lord, at the last pre-trial in the previous history of this matter, in the long litigation history of this matter, there came a stage in 2021. We're now in 2024, the 23rd of February 2021, where the pre-trial minutes for that hearing in 2021 reflect that by that date, the various pre-trial issues that had delayed the trial commencing, and they're well known to everyone and to this court, had been resolved. Paragraph 6 of the pre-trial minutes of 2021 reflect that Mr. Zuma takes note of the reasons that have been advanced by the state for the delay in the trial commencing, and place on record that he is ready for the trial. His rights in this regard are specifically reserved. Then the court, this was now another presiding judge, his Lordship Judge Kun, issued the order on the 23rd of February 2021 that the matter is certified as trial ready in accordance with the Judge President's pre-trial directive, and the matter is postponed to the 17th of May 2021 until 20th of June, and so on for 2 terms, and then to last until the conclusion of the trial at the discretion of the presiding judge and the Judge President. But then on the 17th of May, which was the date that it was due to start, it was postponed to the 26th of May, when there was a plea. So the trial commenced with the filing of the plea, the first plea in terms of 106H to get rid of me, the first recusal application. Litigation relating to that went on and on for a number of years. It resulted it concluded by the 30th of January 2023, 2 years later, when your Lordship presiding came into the trial, and on the 30th of January 2023, your Lordship postponed the matter for trial to the 17th of April 2023. So that was the second trial date which had been determined, the trial then being ready to commence. Then on the very date that the trial was due to start, the 17th of April 2023, before the state could commence with leading evidence, accused number one, Mr. Zuma, filed his second application to get rid of me, the second removal application, this time in terms of Section 35 of the Constitution. He moved that application to get rid of me. Then litigation wended its way through the courts. It caused the matter to be postponed on various matters, on various occasions between 17th of April 2023, when it was due to start, which of course it didn't, to the 20th of March 2024 without evidence commencing. Then, my Lord, at the hearing on the 20th of March, your Lordship handed down judgment in the form of an order dismissing the second removal application, and the court postponed the matter to the 17th of May for a pre-trial hearing. April, my Lord, Mr. Zuma wanted written reasons. On the 12th of April, Mr. Zuma filed an application for leave to appeal. We opposed that application for leave to appeal. We filed our papers on the 23rd of April 2024. There was some confusion about the date on which the second pre-trial would take place. Ultimately, my Lord, if one goes down on page 4 to paragraph 19, at the hearing on the 16th of May, that was the last pre-trial hearing for the adjournment of the pre-trial, your Lordship ordered as follows: as agreed between the parties that the parties were available, your Lordship reserved the dates for the trial to commence and continue to be in the second term of 2025, being 14th of April, and so on, for 2 terms in 2025 until the conclusion of the trial. That was what happened at the pre-trial last time. And your Lordship then, in accordance with the agreement, postponed the matter to today for a pre-trial hearing with that history. As I have said then, we're now at a stage when, in our view, the only matters outstanding are your Lordship's 2 orders in respect of the applications, and also then formally to postpone the matter for trial to the 14th of April next year for 2 terms, and then for further proceeding of the matter if it has not yet been concluded within those 2 terms.
Right, let's just deal with those 2 issues first.
As it pleases the court.
Okay. Let's, Mr. Mpofu, let's deal with the 2 issues first, which are the issues for consideration in my view. Firstly, the request for reasons, and secondly, the application for leave to appeal.
I don't understand, my lord. Let's deal with them how? I mean, address those two issues. Oh, thank you, my lord. Yes. No, thank you, my lord. We for a
The reason President Zuma wanted Downer removed as prosecutor in the case is because Mr. Downer has already commented in public, in the propaganda media stations and also on the newspapers about about facts of the case. He's already found President Zuma guilty without him going through this trial. In the first place, President Zuma was nowhere closer to this deal when it happened. The people who did the arms deal corruption were President Mandela and President Thabo Mbeki. And President Thabo Mbeki said there was no arms deal corruption. That's what President Mbeki said about the arms deal corruption. He said there was no such. So President Zuma said it wouldn't be fair for Mr. Billy Downer to be part of the people who are to be actually the prosecutor in the case, while he's already found President Zuma guilty in the public space. So President Zuma wanted Billy Downer removed as a prosecutor in the case, but the state insisted that Downer should be the one handling the case because of the obvious consequences of what would happen to the case should Downer be removed as the prosecutor. There's quite a lot of things that would be involved. Other people would, the prosecutor will have to start from afresh to learn about the case, and it would give more delays. The case has been ongoing now for more than 25 years. The arms deal happened in 1996, if I'm not mistaken. So it has been ongoing. President Zuma has been in and out of South African courts because of the same case. Now it's more than 22 years President Zuma having been in and out of the court because of the issue. They just want to paint him and they just want to exhaust him. He's an old man. They just want to keep him busy, to disrupt him from focusing in the liberation of black people. They just want to disrupt him from that focus. They just want to finish his money, whatever money he has. They just want to finish that amount of money, even if they don't find him guilty. They just want to exhaust him and somehow find him guilty in the public opinion. But my view about it, they will found him guilty at the end of the day because that is the purpose of the whole thing. That was the purpose of the whole thing when they set it up. The only problem is it has no base. There's no foundation in the case. So but they insisting that this case should stick to President Zuma, even though President Thabo Mbeki has already said that there was no corruption in this case. There has never been any arms deal corruption. Actually, before I continue with that one, let me share this one where President Mbeki is talking again. I shared this at the beginning, but I want to share it again where President Zuma is talking, Mbeki is talking about the arms.
The defense of government. First of all, I've been trying to say to everybody, there was never an arms deal. There was never such a deal. When people use that phrase, arms deal, that means something crooked happened. You entered into a deal. So I've been trying to say, please, can you stop saying this thing about an arms deal? There was no arms deal. There was a defense procurement. Now, as you'll recall, soon after the government had approved the preferred bidders, the controversy started. That there was corruption. So in the end, that joint investigation team was established. Auditor General, National Director of Public Prosecutions, and Public Protector. And in our view, did very thorough work to look at every element of this matter. That is, matters relating to the contracts which the government negotiated with the supplier companies to try and find this corruption. And as you will recall, they then said they didn't find any corruption. Nevertheless, the demand persisted.
When you say the demand persisted, it basically was talking about the demand for him to charge President Zuma at that time about corruption, which President Zuma did not even know about or did not do. So what was persisting, the demand that is talking about a slip of a tongue for him, revealing other issues, but it was a demand that he should charge President Zuma, even though President Zuma was not involved in this thing.
Or not the demand, but the allegation that there was corruption persisted for many years. And again, as you'll recall, there was a demand while I was the President of the Republic that we should set up a judicial commission of inquiry. And I kept saying, can anybody who wants such a commission kindly give me one fact to justify the appointment of a judicial commission, given the work that had been done by that joint investigation team? And nobody ever came up with a single fact to say, no, here is, even if it's a prima facie information which suggests that there might have been corruption, which would then justify setting up a judicial commission. So I'm saying that I kept calling for this to say, please, can somebody come forward with this information to justify such an act? And nobody did.
Nobody brought the information. Nobody confirmed the corruption. That's what President Mbeki is saying about the arms deal. But still, the demand for him to fire President Zuma persisted. The demand for him to fire President Zuma persisted, irrespective of the fact that President Mbeki says the case have been investigated by two different organizations, and both came to the same conclusion that there was no corruption in the arms deal. And the people who were supposed to be charged for corruption, if there was any corruption, it's President Mandela and President Thabo Mbeki. Those are the people who were supposed to be charged on the corruption of the arms deal. Arms deal happened when President Zuma was working as a Minister of Economics in KwaZulu Natal. Minister is it Minister of Economics, Economic Development in KwaZulu Natal. By then, when the corruption happened, President Zuma did not have power. When it happened, President Zuma was just a deputy secretary of the ANC. He did not have power on government or on national government. He did not have such power. The people who had power is President Mandela and President Thabo Mbeki. So if they were the one who were charged about the corruption, it was gonna be maybe make sense. So this one, it does not make sense because he was not even involved in this case.
Change were an agreement with our learned friend that those two issues have to be dealt with first, and therefore with the direction given by your lordship now. My lord, let me just put this into perspective. Of course, we take no issue with the historical account given by my learned friend, as recorded in the pre-trial minute. And we are grateful that the states eventually were now ready at least to deal with the proposed pre-trial. But my lord, we want to address the court on a very important issue to do with the two issues that your lordship has indicated. Your lordship would remember that your lordship kindly excused former President Zuma from attendance, even for the last time, for which we are also very grateful. But
I wasn't expecting to see him today.
Yes, no, he, after the discussions we have had, out of respect of the court, he insisted that he needed to be here because we need to make these, the points that I'm going to make. My lord, our instructions are that the matter of the pre-trial and trial dates and proposed trial dates and so on is very much premature given the two outstanding issues. And this is how it works, my lord. Mr. Downer has correctly summarized the situation, except for his use of the phrase, to get rid of me. Nobody wanted to get rid of him. We were exercising our rights to have a fair trial, which is a very serious, it's a much more serious matter than getting rid of some individual. Those rights to the fair trial, as Mr. Dana has correctly pointed out, caused the postponements from around about April to the time your lordship handed out your ruling as such.
Let's click the like button and subscribe. If you are new here, click the like button and subscribe. This is the Royal Opinion. Click the like button and subscribe.
Now, our position is this. The issue of the recusal or non-recusal of Mr. Downer is obviously intertwined and interlinked with the commencement of the trial. That goes without saying. That being the case, my lord, the NPA has two options. Either it insists on the commencement of the trial on the dates that have been proposed without Mr. Downer, with some other prosecutor. That's an option that's open to it, which has been open to it, by the way, all along. Despite the false accusations of so-called Stalingrad and what have you. If the NPA wanted to call our bluff, as it were, they should have just said, oh, okay, we are using this so-called delaying tactic, we'll just put another prosecutor. The trial would have been finished by now. But they can't have their cake and eat it. They can't want to commence the trial and also retain Mr. Downer. They must choose one of the two. And let me explain, my lord. The application for the recusal of Mr. Downer, just as it caused the postponements before, as Mr. Downer correctly pointed out, is still alive. And what do I mean by that, my lord? I don't have to lecture your lordship about the implications of Section 18 of the Civil Procedure Act, or just the normal consequences of an application for leave to appeal. So in law, we are in exactly the same position that we were in before Your Lordship granted Your Lordship's order, because that is the legal impact of the filing of an application for leave to appeal. Now, the grievance, I think, let me put it that way, and it's not exaggerating it, of former President Zuma is the fact that he has now instituted processes to try and reverse Your Lordship's decision. And quite frankly, those processes, at least until now, have just been ignored. Nothing has happened. And he felt very strongly about this, my lord. I think I don't want to put it higher than that. And actually gave us instructions to take certain steps, but we advised against those steps and said the best thing to do would be to come here, discuss this matter with the court, find out what the position is, and then thereafter he can exercise whatever rights might be available to him. But let me summarize what his position is. His position is that he's entitled to the reasons, like everyone else. Again, Your Lordship knows all the cases. I don't have to cite cases. That courts are compelled to give reasoned judgments so that citizens can know why they have certain orders adverse to them made against them. It's just a constitutional right that flows directly from Section 34 of the Constitution. That you, and the case I have in mind, my lord, is Mpahlele versus FNB. It's a 1997 to SA, I think page 377. It's a decision of the Constitutional Court, paragraph 12.
Page again?
Mpahlele.
Yes, the full citation. It's in
Oh yes, it's 1997 to SA 377, 677.
Yes.
Paragraph 12, I think Goldstone HA said that the duty of a court to give reasons for its judgment is a concomitant part of Section 34 of the Constitution, the right to a fair hearing and so on. The Lordship knows that. But he made a further observations that duty also vindicates, not only vindicates Section 34, but also gives the citizen the right to know why they have had an order against them. But more importantly, he said, which is relevant to today, he said that right, or rather the acquisition of that right, also is helpful to the Court of Appeal, because the Court of Appeal would otherwise not know what it is dealing with. And that then brings the matter directly to where we are, which is the linkage between, we've spoken about the so-called two issues, the linkage between those two issues. So the reasons give you the ability to appeal. And that appeal is itself a self-standing right. Again, Your Lordship knows this, that although the right to appeal in civil matters is, if you like, implied in Section 34, and our courts have accepted that. But when it comes to criminal matters, the right to appeal is not implied. The constitutional drafters decided to spell it out in Section 35.3.0. 35.3.0 of the Constitution. And why is that? It is because the right to appeal in the criminal context is a fundamental right which needed to be spelled out explicitly.
Let's remember that President Zuma it's not for the first time that he's been refused to appeal. Um, the previous time when President Zuma was abducted or kidnapped to jail by the mafia government, he was not given a right to appeal his case. So even here, they did not give the reason why the ruling was against President Zuma in favor of Downer. No reason was given. So that President Zuma does not have the ability to appeal the case in the higher court. Because for you to appeal the case, you need the reasons why you were not successful in the previous court. So that the new person who is handling your appeal will be able to understand what is happening in the case. Is it fair or not fair? So, but if he's not given that opportunity, then his right to appeal again has been violated like they did in the previous case. Let's continue to listen.
By the Constitution. Now we're in a situation where we are, our hands are tied in that we are unable to exercise those rights. And I may add, my Lord, at least to the credit of the NPA, when they received our notice, as your Lordship knows, then they filed their notice to opposition and put the grounds. So in legal terms, that means we have what is called a dispute. We've put our grounds, they've put their grounds for opposition, and that's a dispute. And Section 34 says that every citizen has a right to have a dispute resolved before a court of law, an impartial court of law at that. Now, so that's where we are, and therefore, my Lord, we would humbly request the court to grant former President Zuma his rights to be given reasons for the adverse decision and his right to appeal it. And that's not strange, my Lord, because the parties went into the trouble of pleading and so on, counter pleadings. Your Lordship went through the trouble of listening to the arguments, and your Lordship came to a determination. That's all very well. But we are entitled not just to the determination, but to the detailed reasons, so that if we are happy with the reasons, we might be, then that might be the end of it. But if we are not happy, then we would exercise the other right. And my Lord, this court is familiar with this. This is what happened here in relation to the Section 106 matter. And this is what happened in relation to the recusal application of Judge Kuhn. So it's not something that's just like some new procedure that we're inventing. And I want to end it with this example, my Lord. If you remember when Judge Kuhn's application came, or rather recusal came, he indicated his discomfort, and we supported his recusal. The state opposed it. Well and good. Again, then there was a dispute. And therefore, it was argued, and then he came up with his judgment shortly before the beginning of last year, which eventually ended up with your Lordship now being settled with the case, to cut a long story short. Now, imagine, my Lord, if the Judge Kuhn or the state, which was the aggrieved party then, because the judgment was theoretically against them. If the state had said, we want to appeal Judge Kuhn's judgment because we don't believe he should have recused himself, or if he had found against us, we could have done the same thing. And then Judge Kuhn would have had the leave to appeal, granted it or not granted. We couldn't ask him for reasons because he had already given us reasons. Now imagine if in that scenario, Judge Kuhn then said, oh, by the way, can you come in March or April for a pre-trial so that we can set the trial date? That would have been absurd. We would have said, what are you talking about? Because all that is dependent on your recusal or non-recusal. So we're exactly in the same situation. From a legal point of view, the recusal of a judge or the recusal of a prosecutor has exactly the same consequence. Because the so-called pre-trial, the so-called trial to which this is supposed to be a pre-trial, as we speak, is a trial that is run by Mr. Downer, the potential recusee. And so that's really the to just clarify the issue. Just 1 second, my lord. Yes. Oh, yes. Just to explain, so that's the position, my lord, as to what Mr. Downer correctly said, that they sent us documents, we did not respond. And that's really the context, because our client has insisted that we must not put the cart before the horse. Let's start with the horse, then we will deal with the cart.
They are in a hurry to nail President Zuma. They are in a hurry to find him guilty of corruption that he did not commit. So they want to push everything else, even his rights must be pushed aside so that they can be able to quickly find him guilty in the court of law and try to stop him from his work, which is currently doing the work of fighting the white establishment, the white system. They want to remove him from focusing in that work and make him focus on keeping himself out of jail. That is what they want to keep him doing. If possible, they want to take him to jail and to lynch him, to basically lynch him, because he's a problem. Why does he stand for the truth? And why does he love black people so much? Why can't he take some money and go home? They are angry against him because of that.
Section 8, yes, I've already addressed. So, one of my colleagues was reminding me about the Section 18 point, but I've made that point earlier. As the court pleases, my lord. So let me just check.
Yes. Yes. Application for leave to appeal?
What about it?
You are only going to address the issue of the application for leave to appeal once I made a decision on the...
Yes, no, my lord, we didn't come here for any application. We came here for a pre-trial. And we never were told that there's a set down for an application. I think that's not what Mr. Downer was saying as well. Mr. Downer was saying that there should be an order. He was almost suggesting that there should be an order without argument. I've never understood that there was a set down for that. Let me just...
Yes, just yeah.
Okay, maybe it's me. No, my lord. No one has ever indicated to us. We would have, in fact, we would have welcomed it, obviously, because that's what we want. But that's...
Yes, I was under the impression that the two issues that are going to be dealt with are, firstly, the request for reasons, and secondly, the application for leave to appeal, the order of the court.
Yes, my lord. No. To be dealt with in the context of the pre-trial, of the summary that Mr. Downer has articulated. I don't know about Mr. Downer. Let me just check with him. Did you want to run the application?
Yes.
No. Well, he says he wanted to run the application. Well, in any event, that's irrelevant because we cannot run an application for leave to appeal without reasons. I think that would be, I certainly have never been told that there's a set down date for the application for leave to appeal. That might just be a misunderstanding, my lord. I don't want to make much of it, but the substantive point is that in any event, even if we were told, we would have come here to say we need reasons
First, before we
first,
put an application
exactly.
for leave to
So
appeal.
that remains our position. As a lordship, just the sequence is really reasons, application for leave to appeal, then we can get into the trial and pre-trial issues. And as we sit here, unless if my
But
attorney,
in the correspondence that
my attorney assures me that he hasn't had any reasons or a response to the request for reasons.
I see. All right. Yes, all right. Let me hear Mr. Downer then.
Yes, my lord. I apologize.
Thank you, my lord. Just a few preliminary points in answer, my lord. First of all, my learned friend develops an argument here today without any indication or notice to the state or the court what he's going to say.
Click the like button and subscribe. This is the Royal Opinion. My name is Mugani Mkonto. This is the framed charges against President Zuma, the concocted charges against President Zuma going on. Click the like button and subscribe. Let's continue to listen.
My lord, we served the draft pretrial minutes on the defense and on the defense with an invitation to join in the creation of pretrial minutes with the consent of all the parties. They declined to do so. There's no reason for them to decline to do so. If my learned friend wanted to make the points he's making today, he should have made them in a pretrial minute so that we could all be apprised of his attitude and be prepared to answer whatever arguments he's brought up. And he's brought up new arguments today, which we were not apprised of beforehand. Nevertheless, I'm quite prepared to answer them, and I intend to do so. But nevertheless, that method of litigation, simply to leave it and not even answer the state, not even pay the court the courtesy of apprising the court as the parties are enjoined to do in the Judge President's pretrial minute directive of 2018, to apprise the court of what is going to happen at the pretrial so that everyone is properly prepared, so that the pretrial may be concluded, and so that the matter may not be adjourned again for yet another pretrial. And remember, we're in the third pretrial now. We've been trying to get the pretrial going since April. So, my lord, we take exception to that, and the answer to that is not to grant a postponement, but to deal with the issue.
You need to get to a pre-trial in a fair way. You don't just push for a pre-trial unfairly and in the process destroy other people's rights or ignore other people's rights. You have to get to pre-trial fairly, both parties. We're talking about jail term here. We're talking about somebody separating from his wives and children and grandchildren and going to stay away in jail. You can't just do it like that. It's not allowed.
Today, and I submit with great respect that we are able to address the court meaningfully, and your lordship, I submit with great respect, is also able to do so. All the issues are live before the court and have been properly addressed in the papers before the court, even though my learned friend has not seen fit to provide us, as he should have, with his input in the pre-trial minute. But we'll leave that then for the moment. My lord, our answer to the application for written reasons, together with our answer to the application for leave to appeal, is contained in our answering affidavit, which we filed in due course with this court, and is before the court. And we deal with both those issues, both the issue of written reasons and the issue of leave to appeal against your lordship's judgment. My learned friend also, just as a preliminary issue, my lord, fails to accept that as we now here stand, this court has dismissed the second application for my removal. So as we now stand, I'm not removed. There is an application for leave to appeal. That doesn't change the position in this court that as far as this court is concerned, I am, the application has been refused, and the application for leave to appeal I submit can be answered, and it should be answered, as we say in our papers, to be dismissed. If I could then turn, my lord, to our papers, our answering affidavit, if I could just take a moment to get to it.
Sorry, Mr. Downer, I think Mr.
Yeah.
Yes, Mr. Mpofu.
My lord, I object to this. We don't want to play games here with the court. I thought your lordship was giving Mr. Downer an opportunity to respond to what I was saying as to what is going to happen. He's now delving into responding to an application that has not been moved by anybody. And so I don't understand that procedure. The question is whether if the court is prepared to hear the application for leave to appeal, whether that should happen before or after we are appraised of reasons, have engaged with those reasons, and as I said, we might even decide to withdraw our application for leave to appeal if the reasons are good enough, if we are aggrieved. That's why in our notice, your lordship, you'd have seen that we said we reserve the right to expand on our application for leave to appeal once the reasons have been furnished. Yes. So that's really the only issue to be addressed, and not for him to just dive into the actual application. And I would appreciate it if he addresses, or rather responds to my address on that. But as far as the telling the state what we want to do, or we are raising new argument, we haven't raised. What new argument have we raised?
All right, let's deal with this way, Mr. Mpofu.
Yes.
I'm going to ask Mr. Downer to confine himself to the issue pertaining to reasons.
Yes.
Then thereafter I'll allow the opportunity to reply.
To respond. I'm happy with that, my lord.
Yes, thank you.
I hear you, my lord.
Yes.
My lord, could I just draw your court's attention to this issue of whether we were due to move the application today? If one looks at the pre-trial minutes of the 23rd of April, 2024, which is cited in today's pre-trial minutes on page 3 in paragraph 14. So look at today's pre-trial minutes, that's the 29th of August, where we cite the previous pre-trial minutes, and we say that on the 23rd of April, when the trial was due to start and the matter was then adjourned for
will be to consider the request by Mr. Mpofu on behalf of Mr. Zuma for reasons for the order I made on 16 May 2024, dismissing Mr. Zuma's request for the removal of Mr. Downer as the prosecutor in these proceedings. Having considered submissions made by counsel, I am of the view that exceptional circumstances exist that warrant the grant of the request by Mr. Mpofu. However, due to other commitments, I will only be able to do so either on Tuesday or Wednesday week after next, that is the 10th or the 11th of September 2024. I'm therefore going to request counsel to avail themselves on either one of these 2 days.
As it pleases the court, my lord.
As pleases the court, my lord, we are available. My lord, do I understand that that's the date for the delivery of the reasons?
Reasons,
As
yes.
the court pleases.
Just a moment.
Yeah, the state is available, my lord.
Right, this matter is therefore adjourned to 11 September 2024, and reasons will be finished on that day.
This is Scotland.
The judge there making a decision in favor of President Zuma, in favor of Dalimpofu, that they should have the reasons before the trial can start. It's fair that way. They are entitled to have the reasons before the trial can start. So the judge, being so, click the like button and subscribe if you are joining us for the first time. My name is Mngoni Mkonto, and this is the Royal Opinion. We're addressing the issue of President Zuma, who has been granted date for the reasons to be granted by the court, because it was not granted the reason why they found. Basically, I don't think the judge actually does have the reason. They still have to go sit down and draft the reasons. They only wanted to push for the trial for Downer to be the state prosecutor. But President Zuma is feeling strongly that the judgments were not in accordance with the law. He wants to appeal against the judgment of the court, that Downer should stay as a prosecutor in this case, because there are evidence, hardcore evidence of what President Zuma is complaining about. So this evidence cannot just be ignored by the courts. So the judge there, agreeing with President Zuma that there should be reasons. He should be granted the reasons. So earlier on,
We filed a notice of opposition, then, to quote the pre-trial minutes, to be moved at the hearing on 17th of May 2024. So it is indeed a live issue. We gave notice that we were going to move it on the 17th of May. Today is an adjourned hearing on the 17th of May. So my learned friend is incorrect to say that we did not give notice that pre-trial hearing, which is today, we will be moving for the application to be heard. And the fact that he didn't engage with us and with the court in the pre-trial minutes is not of our doing. So he has notice. Today is to move the application, but let us then begin, in accordance with your lordship's order, to start with, has the court given written reasons? If I could then move to our affidavit in answer to Mr. Zuma's application for leave to appeal. We deal with this issue, if we could just get to the right place, my lord. I'll be with your lordship in a moment. And first of all, my lord, just to make the point that this method of litigating without notice, without engaging with the state in the pre-trial minutes, and with, no doubt prefaced, as my learned friend says, with a further application for a postponement, is in accordance with what has already been found.
you can smash the super thanks button there to donate to the Royal Opinion. Click the like button and subscribe. You can join the channel to become a member to support the Royal Opinion. This is where we give political news and information, different opinion from the mainstream media. You can support us. we will really appreciate your super thanks.
To be by this court, full courts of this division, and the higher courts as an abuse. We make that point at paragraph 4 of our application. My Lord, I'm getting to the point. My learned friend could just give me and stop interrupting me.
My Lord, I'm not going to take that kind of abuse from Mr. Downer. I have a right to object when I feel that there's an objection to be made. And he has assured me that he'll get to the point, and I sat down. So I'm not going to be abused by him gratuitously. Thank you.
Lord, I shall proceed with my argument. Let's get to the point, my Lord. At paragraph 10, my Lord, of our affidavit, at paragraph, I'm getting to it now. As it pleases the court, at paragraph 7, we say that it was on this basis that your lordship ordered that the application for the removal of me as the prosecutor in the criminal prosecution of Mr. Zuma and Tali's was dismissed with more substantial reasons to be incorporated in this court's judgment at the conclusion of the trial. And your lordship further clarified to Mr. Zuma's counsel that the substantive reasons for the ruling will be incorporated in the court's judgment at the end of the trial. We say that the court has a discretion in these matters when the interlocutory rulings given, that the court gives reasons in the discretion.
It does not make sense at all. You say you want to give the reasons why certain judgments were made in favor of others at the end of the trial, but President Zuma has to appeal, needs the reason in order to appeal or to continue with the trial. He needs the reason why did the court found in favor of Mr. Downer. Those reasons are important for the case to be able to continue in a fair way. So this kind of argument is just arrogance. It's just white arrogance. It has got. I mean, why would you say somebody should not be given a right to reasons? Why should that be a discretion of the court? The arguments of these people, it's disheartening sometimes.
Of the court, which may not be full reasons, but that the court at the end of the day gives full reasons during the judgment on the merits, if necessary, and that is in the discretion of the court. The fact that in different circumstances His Lordship Judge Kun might have chosen to give full reasons in a different application at a different stage of the proceedings is no precedent for this court to follow to say that full reasons have to be given. And we say at paragraph 6, if I could just return for paragraph 6, we say at paragraph.
No, I see your comment, Mpilo Rodney. You say his comment says your analysis suck. You don't understand the law. Make us understand the law. How does the law work when it says somebody will be given the reasons at the end of the trial, while actually he needs the trial in order to he needs the reason in order to continue with the case? How does that work? You can explain to us, Rodney. My analysis may suck, but then give us your right analysis there. That one I don't understand. Why would they say somebody must not be given the reasons why they found in favor of the other person? If this is my case, I need to understand why. What was the reason they found me guilty, or what was the reason they found in favor of my opponent? I should understand it. Moeketsi Tsiye says, "Are you a lawyer, my brother?" Asking, I am not a lawyer. I'm not a lawyer at all. I'm a citizen of South Africa whose laws affect. So this is law is not for lawyers to talk about. It's for citizens, for everybody to talk about. Because at the end of the day, President Zuma is not a lawyer here, but he will get arrested if found guilty. So citizens have a right to understand the law and have a right to talk about the law. Whether they understand or they don't understand, it does not necessarily matter. If we don't understand, then make us understand. I'm not a lawyer, my brother, there, just to answer you. I'm just a person who is just analyzing based on what they are saying here. I mean, if they say you are found guilty and you have to go to jail, but you will not be given the reasons why you were found guilty. How is that any fairness? Is there any fairness uh, in such a thing?
6, we say, it is not correct that your lordship did not give reasons for your lordship's ruling on the 20th of March 2024. This court, my lord, informed counsel that the court had decided in the interest of justice and in accordance with section 173 of the Constitution to incorporate reasons for the order that would follow in this court's judgment at the end of the trial. And the court, my lord, provided reasons in your lordship's judgment, including inter alia the following. Paragraph 6.1. The question which required, this is what your lordship's reasons then included, and these are your lordship's reasons. The question which required determination was whether the retention of me as the prosecutor in the present matter would infringe Mr. Zuma's fair trial rights, entrenched in the Constitution. Having considered the 4 pillars which were put forward in my learned friend's papers in the application for leave for removal, Mr. Zuma raised in support of his second recusal application the very same issues in this application for leave to appeal, which have already been decided by our courts, as explained above. Your lordship emphasized that having had regard to the submissions made by counsel, the relevant case law, and most importantly, the 4 pillars relied on by Mr. Zuma, this court was not persuaded that Mr. Zuma succeeded in establishing that the retention of me as the prosecutor in the matter could prejudice his right to a fair trial enshrined in section 35(3) of the Constitution. And then, as I've said, it was on this basis that your lordship ruled that the application should be dismissed. So it is not correct that no written reasons were given. It is correct that written reasons were given. The fact that my learned friend might be dissatisfied with the nature of those reasons or that they were too short is an issue which can be taken up on appeal. It is not it is not an issue which is terribly live before this court, except that my learned friend has now launched a substantive application, and that substantive application needs an order. But the order is already there in your lordship's judgment, previously given on the merits of the application itself, and therefore the court's order is simple, what the court can order today, without any further reason for postponement or further argument. Your lordship would simply refer to your lordship's judgment with great respect and say that reasons have already been given, and therefore the application for reasons and or for further reasons is dismissed, because your lordship has already ruled on it, and in effect your lordship is actually functus officio. So the order is just a matter of course. So therefore it need not be postponed, and your lordship is at liberty, I would submit, should your lordship feel so disposed, to give such an order today without any further postponement of the matter on that issue. Furthermore, my lord, the matter is, because of the development of this matter, the different circumstances and the rulings of the various courts, the imperative for this trial to start without any further imperative relating to this issue is just as strong as it is on the merits of the application for leave to appeal itself. So in that respect, the mala fides, the lack of good faith which have been found by the various courts, including this court, full courts, and the Supreme Court of Appeal, and by implication the Constitutional Court, all those issues were not issues which had been crystallized by the time that His Lordship Judge Kun, in his wisdom, decided to give reasons in a previous application. So it is of no application, I submit to Your Lordship now, and Your Lordship is at liberty to say that, reasons have been given and the application is dismissed. If just one final point on that, I seem to remember, my Lord, I haven't got it here with me because I didn't have notice, but I think there was correspondence between Your Lordship's registrar on copy to us and Your Lordship by my learned friends before the substantive application, requesting reasons informally. And I seem to recall that Your Lordship, in fact, sent an informal email or letter, we can get a copy of it in due course, to say that those were Your Lordship's reasons. So if that is so, if my memory serves me correctly, and I think it is, that is further reason why Your Lordship is at liberty now to simply issue the order that no further reasons will be given, and we can then move on, if I must now confine myself to that issue, to the other issues as Your Lordship directs. May it please the Court, my Lord.
Yes, thank you, Mr.
Listen to that kind of suggestion. Listen to that kind of arrogancy from the white system to say, ignore his rights, don't care about his rights to know the reason why they found in favor of me instead of him. Ignore his right. Just push and say, just ignore him. Let's just push this case for him to go to trial and be found guilty. When he is guilty, then we will see to what reasons we're going to give at the end of the trial for this case. That kind of arrogance, it's actually sickening in my eyes.
Yes, Mr. Mpofu.
Lord, let me start. I think I understand what Mr. Downer's problem, or where we are not finding each other is now. So I'm indebted to Your Lordship for having given him that opportunity. My Lord, this is what it looks like, my Lord. Firstly, let me just put Mr. Downer at ease about, he's saying we did not apprise the court of what we require. We don't apprise the court by phoning the court or sending emails or whatever. We apprise the court by filing notices. That's what the rules say. So we filed a notice requesting reasons. We filed a notice for application for leave to appeal. That's how lawyers communicate with the court, by process, legal process. And that's what we did. So the court knows, and Your Lordship has indicated more than once, at least today, how the sequence of events should follow. And therefore, if one follows the sequence of events mapped out by Your Lordship, we are now at issue number 1, which is the issue of reasons, which Mr. Downer has addressed. Well, this is our response to this. Mr. Downer is just being downright disingenuous, because he stood up here, he properly explained the position as indicated in his draft notice, draft minute. And now he is shifting his position. He now wants to move an application. If he was here to move an application, as he says, why did he not move it before I spoke? He's only moving it now because he wants to opportunistically take advantage of a situation of the misunderstanding that we spoke about as to what is the purpose of today. Is it a pre-trial, or does it also, and I can assure your Lordship that seems, at least to me, between us and the court, to be a genuine misunderstanding. That's neither here nor there, because that can be dealt with. My Lord, if Mr. Downer was here to move an application, as he puts it, he knows what to do. He would have served us with heads of argument. We would have served him with heads of argument. We would have given those heads to your Lordship. We couldn't just come here with senior counsel on all sides to just talk without your Lordship not even knowing what is the ambit of the issues, what cases are being relied on, and so on, the usual manner. And if he had come here to move an application, as I say, he would have moved it. He can't come here and try to move an application from his opposing affidavit. And it's not true that their notice was to move an application. That's just false. Because if you go to page 1 of the state's notice of opposition to Mr. Zuma's notice of appeal, it says, kindly take notice that at the pre-trial hearing set down on 17 May, the state intends to oppose, not to move, like he was saying now, the first accused application for leave to appeal. Now, it's not for Mr. Downer to set down an application on a particular day. If on the 17th of May, the the application for leave to appeal was set down for that date, then of course it's their prerogative to oppose it. But, my Lord, believe me, that has never been our understanding, that the pre-trial is kind of rolled into one with the application for leave to appeal, without reasons, no harm. That procedure I've
Thank you, Mr. Mekitsi, for your comment. Thank you very much. Everyone can comment in the comment section. Tell us what is your view about my analysis. Maybe I can listen to what you are saying and improve. It does help sometimes. If you need to comment about improving or any comment that you need to talk about, you can just comment about the case. Mr. Moikitz, I talk about the reason I mention white. It's because I'm well aware that this is a witch hunt. This is not a real trial for corruption. President Zuma was never involved in any corruption. So this is a war which has been taken to court to remove the leaders who want the liberation of black people. Black people are still colonized by the British Empire and the American Empire. The two empires have colonized Africa and black people. So in these courts, this is their own environment. This is the Roman Dutch law, which they are taking our leaders to, in order to remove them from the focus for fighting for black people, in order to exhaust them for fighting against the system, for daring to fight for black people. They wanted them to sell out. If you are a sellout, then they won't give you problems like this. For 23 years, President Zuma has been coming in and out of court of the same case. This case started in 1996. As we all know, that President Mandela and President Mbeki are the ones who did the arms deal. Instead of looking at the solution for electricity, because they wanted to distribute electricity to black people, instead of going for a nuclear power, they go for arms deal, to give the arms companies their share from the deal, from the negotiation in Codesa. So I speak about white people in that context when I'm very much clear in understanding that this is not a normal case where it's a trial of somebody who is guilty of anything. This is a witch hunt. It's only to remove black leaders and to defocus them from their work.
I've never heard of it in my
Click the like button and subscribe. My name is Mngoni Mkhonto, and this is the Royal Opinion.
experience. And so the snatching at the bargain and moving as we go along, Mr. Dana, at the slightest provocation, always comes with heads of argument about even when they are not necessary. Why would he, coming here for two substantive applications, just rock up and make an address without any reference to any authorities? It's just not true, my lord. Besides, the lie in this approach is as follows. Let's assume in his favor that he came here to argue the issue of reasons, for argument's sake. Then your lordship would have listened to both parties and made a ruling on that issue. Then how can he, in the same breath, say he's also here for the application for leave to appeal? Because that let's assume your lordship agreed with us and then gave the reasons. Then what would happen? The next 5 minutes we are ready to argue an application for leave to appeal. Obviously not. There's no such legal procedure that Mr. Downer can point us to. So it's just a complete disingenuous way of litigation. But be that as it may, my lord, the law is not what Mr. Downer is telling us. Remember, my lord, one of the issues in the application for leave to appeal, which will be debated in due course, is that Section 316 of the criminal procedure doesn't apply. Fair enough, they can make that argument. But surely we have a right then to make the counter argument. Surely. And I'm not arguing the point, my lord. I'm just demonstrating the fact that there are things to be debated by both parties, and the court must pronounce, and then we move on to the next stage. I'll just give your lordship a taste of what we are talking about in regard to the leave to appeal. Your lordship knows that Section 316(1)(a).
Mr. Prof, I'm now dealing with the application for leave to
No,
appeal.
I'm not, my lord. That's why I made that qualification. Believe me, I'm not. I wish I could. No, I can't. I'm simply just demonstrating. Please, my lord, if your lordship bears with me. I'm saying their position is that you must be convicted of an offense and so on. We know. Our position will be that when that day comes, that when that section says that the court must give leave to appeal against such conviction or against a resultant sentence or an order. Yes. And your lordship knows that debate. It's been going on for. So our position is that, yes, you can ask for leave to appeal against a conviction. Yeah, of course you can ask for leave to appeal against a sentence, but you can also ask for a leave to appeal against an order. And that is why Justice Kuhn.
My lord, I must object if my learned friend would give way, similarly to the way I gave way to him. I don't understand the argument now. We're dealing with the issue, should your lordship now give an order and the terms of the order and the procedure relating to the order, relating to written reasons. The argument which my learned friend is now proceeding with doesn't address that issue. So just as he objected against me seeking to take it further, I object to him taking it further.
Yes, I agree with
Ma-
Mr.
yeah, no, I agree with Mr. Downer as well. My Lord, I've made it clear. I'm not addressing
The issue of,
the argument now, yes. I'm simply making an illustration that the matter is not as simple as Mr. Downer thinks it is. It's a matter that is going to have to be, even that issue, that's going to be debated in the application for leave to appeal. I'll leave it at that because I don't want to create an unnecessary debate. The simple point I'm making, my Lord, is that all these issues are going to be debated in good time when that time comes. For now, our position is very simple. That I mean, Mr. Downer is telling this court that the following: having had regard to the submissions made by counsel, the relevant case law, and most importantly, the four pillars, he was not, my Lordship, not persuaded that Mr. Zuma's application must succeed. He calls that a judgment. Honestly, well, if judgments were like that, our law reports would be very easy to read. This is an order. How can you have parties that have pleaded to thousands of pages, have put legal arguments, cited many cases, and then an order is granted, and then you call it a judgment? It's obviously not a judgment. So if I were Mr. Downer, I would argue...
And just to add to that, for the sake of brevity, Mr. Mpofu, I specifically indicated that reasons will be incorporated in the judgment.
Your Lordship has taken the words out of my mouth. That if I was going to say, if I were Mr. Downer, at least I would argue along those lines that the reasons are outstanding and they'll be given at the end of the trial, and then the debate would be at that level. But you can't come here and try to pretend that this is a reasoned judgment. I mean, that's just ridiculous. Because your Lordship made it clear that your Lordship knows he couldn't have just ignored all the cases that were cited. It's a question of when. Now, our position on whether or not that should be the case, my Lord. If I can just refer your Lordship to. I promise it won't be long, my Lord. It's at 31-12 of Dutoy. It says, yeah, the heading is leave to appeal, of course, before conviction or imposition of sentence. The first paragraph just states what I've already said about
Gosh. I was actually talking without the mic. I only realized that I don't have a mic after I spoke for a few minutes. I was just saying, let us remember that the CR17 money has been dispatched to judges as well. The money were paid to judges and sub-magistrate. So we don't, even now, the public protector's report is sealed by the courts or by the judges, so that the public should not know who bribed who. We still don't know who is confusing the public in these judges, and of which I feel it would be fair if we all know.
The rights, Section 35(3)(0) of the Constitution and so on. And then, yes, the important part, it says, in exceptional circumstances, however, leave to appeal before imposition of a sentence, and I suppose conviction as well, may be granted. Essentially, this will be limited to situations where it is in the interest of justice to entertain an appeal before conviction. And the cases are S versus Western Areas, 2005 1 SACR 441, SCA Zweni, the well-known Zweni case, and S versus Zuma, that's the judgment of Kunje, yes, which has now found itself in the academic. So, again, I'm not arguing that point now. I'm simply clarifying that the position of Mr. Downer is untenable. Remember that, fortunately, the position of Mr. Downer is on paper, so he can change it now as much as he likes. But the position is captured in his notice, and he says that there should be an order granted and then 2 orders granted. But how can you have 2 orders granted without legal argument? And how can you have those orders which are in a way not symbiotically, the one depends on the other. In other words, the leave to appeal depends on the reasons, all granted as if it's just one application. So, my Lord, we're not seeking any postponement. I heard Mr. Downer talking about seeking a postponement. All we're saying is that we should be put in a position to deal with both of those issues, the issue of whether or not we're entitled to reasons, as well as the application for leave to appeal itself at the appropriate time. And in our respectful submission, that was neither of the parties, if you use this as the evidence, came here under the impression that that appropriate time is now. That's.
Sorry, before you sit, Mr.
Yes,
Mr. Mpofu, can you refer me to any particular authority that obliges the court to give reasons when the trial is not been finalized?
Yes. Okay. My Lord, I'm saying this.
Even if there's no authority, can as a human being, can't you see that you need to give reasons why you are finding the other person guilty instead of the other person? Like, reasonably, being a human being, let's not complicate law. What is law? Why can't you just give the reasons why you are judging on behalf of the other person, besides the authority that you are requesting now? Besides the authority.
I've actually given your Lordship those authorities, but let me unpack our submission very succinctly.
But those authorities deal with application for leave to appeal, yes. And it says that those authorities, I think the authorities who gave me now deal with exceptional circumstances where the court can grant leave to appeal, yes, in instances where the matter has not been finalized. Am I right?
Yes, my Lord, of course. In other words, even on the interpretation of the state, it would be the exception to the general rule. Yes, no, we're on the same page, my Lord. Let me put it like this, my Lord. In our respectful submission, the right to appeal, which obviously includes the right to leave to appeal, goes symbiotically together with the right to reasons.
I see.
Because you can't, an appeal against what? So, right?
Just a moment. So, please,
Yes.
I follow the argument. Right now, you are stifled. You can't do anything because you don't have any reason.
Absolutely, my lord. So it is cold comfort. It would be an empty right to say, oh, you have the right to appeal, but we are going to withhold the reasons. That's the same as denying someone a right of appeal. Because it's like a pretend right. You say, oh, no, you can appeal, but I'm not going to give you the reasons. So the one, that's why I was using that metaphor of the horse before the cat, or the cat before the horse. And so if the position of the state is that the reasons are not due, but the application for leave is due, then we differ with that vehemently. And our position would be this, my lord, that your lordship, particularly on an issue like this, my lord, your lordship is quite correct. I mean, if the court decides, look, we're going to sit at 11 o'clock and not at such and such a time, I'm making that ruling. I can't say, well, I differ with you, my lord, I want reasons and I'm going to appeal and so on. So there are those types of matters, of course. That's why exactly the wording of exceptional circumstances is used. But, my lord, these are quite self-evidently those exceptional circumstances. Why? Because of what I said earlier. Because the question of the recusal or non-recusal of Mr. Downer is but intricately and inextricably linked with the so-called trial that was supposed to be in a pre-trial about today. It is that simple. It's not an issue, because what is the opposite, my lord? The opposite is that we must be appealing and making an application for the recusal of Mr. Downer. But at the same time, go through a 6-month trial with Mr. Downer. What is that? The very same person who is the subject of the ongoing appeal, at the end of which might be found that he should not be here.
Where is the logic in that? What is the logic in that? What is really the logic in that? If you listen to what kind of argument is that? Is a lawyer, what is he arguing? Mr. Downer. How can you say what Downer is saying? How can you say reasons should not be given? The case should continue without reasons, and then reasons will be given at the end. While they want to remove him. They want him not to be the prosecutor in the case. So the court found in favor of him. President Zuma want reasons why they found in favor of Downer instead of him, because he had compelling reasons why he wanted him out of the case. But here the Downer saying everything should be ignored. Shockingly.
Because unless if he knows something we don't know about the Supreme Court and all the other courts, nobody, not your lordship, not me, not anyone, knows what the outcome of that appeal is going to be. So let's say it's 50-50. If the appeal says Mr. Downer stays, he must stay. But if the appeal says he must go, he must go. And what then would be the logic of running an expensive trial when there's a 50% chance, and I don't want to put it higher than that, that Mr. Downer is not the right person to prosecute the case? I mean, it's illogical. That's why I made that example about Judge Kuhn. Because he would have then said, okay, I know you've appealed my recusal, but let's get on with the trial, effectively. How would he do that? Because we would say, well, we get on with the trial with you, and then somewhere in 2 years' time, it will be found that you should have recused yourself. Then what would have been the point of that exercise? It's completely illogical. It can't work, my lord. It's the one thing literally depends on the other. That is why your lordship, when your lordship got into this case, postponed the matter so that your lordship, must first make the decision on Mr. Downer. That was the logical thing to do. Otherwise, your lordship would have come here in February, March, I can't remember when your lordship assumed the case, and said, well, let's get on with it. And I would have stood up and say, well, my lord, there is the issue of Mr. Downer's recusal. Your lordship would have said, I'm not interested in that, Mr. Mpofu. Call your witness or whatever. But your lordship didn't do that because it would have been illogical for your lordship to do that. Why is your lordship being asked to do something that he would logically not do when you assumed the case? Because for all intents and purposes, we are exactly at the point. I know your lordship has made your ruling. We respect your lordship's ruling, of course. But the law is that we are now in the position where we need the same judgment, but from a higher court on the issues that your lordship has determined. And we have a right to that. It's not a favor that we're asking. We insist on that right. We have a right to have that matter adjudicated to, if we're not happy with your lordship, we have a right to go to the next court. If we're not happy with that court, we have a right to go to the next one. So what is being suggested here is that, unlike all the people in this country, Mr. Zuma only has a right to hear the ruling on the recusal of Mr. Downer from one judge, and he must live with it forever. Amen. What is that? There's no human being who has a right like that. The reason we have a hierarchy of courts, lower courts, the Supreme Court of Appeal, and the Constitutional Court, is because it is known that judges may err. Judges are the first ones to admit that they may err, and the position might change if another court. Why? I can't understand why Mr. Zuma must be denied of that right. Really, it beats me. And therefore, he has that right, and that right cannot be exercised unless he has been given reasons. Because to refuse to give him reasons is the same thing as refusing him that right. That's our position is very, very simple.
There's something that Mr. Masumbu asked.
Okay, sorry.
A very, very sensible argument from Advocate Dalimpofu. Very, very sensible kind of argument. Very illogical from Downer. What is trying to argue in the court, very totally illogical. Unreasonable people, unreasonable person, Mr. Downer. Totally illogical in his argument to say that President Zuma should not be given the reasons, but the case should still continue with him as a prosecutor in the case. It should just be amen and amen. Has got no right to do any other thing other than allowing. We must really appreciate Advocate Dalimpofu's arguments here.
It's fair trial rights. We've dealt with that,
Yes.
as court pleases.
Yes. Yes, I need a moment to consider my ruling as metal stander.
As pleases.
Yeah, the judge wanted some time to consider his ruling. At the end of the day, he ruled in favor of President Zuma, at the end of the day, ruled in favor of President Zuma to say reasons will be given on the 11th of September. The reasons why they found in favor of Mr. Billy Down will be given on the 11th of September. So we have a date on that case, and then after that, President Zuma would have to decide whether to appeal the reasons or to just go on a trial. If he decides not to appeal, then the trial will go and start. If he decides not to appeal, the trial will stop. That is what is going to happen. Thank you very much for joining the live stream. We're going to end the live stream at the moment. We're going to end it here. We will meet next time.